Hi, Leanne. How are you?
I'm good, thank you, Michael. How are you?
I'm wonderful, thank you. Looking forward to our chat today. Today, I think, is going to be, we're going to talk about the most popular question that I get as a realtor, and I'm willing to bet you get as a lawyer. But before we start, why don't we introduce ourselves for those who may not know you or may not know me? Why don't you go
That
first?
sounds good. I'll go first. So my name's Leanne Townsend. I'm a family law lawyer in downtown Toronto. I'm a partner at the law firm Brody Thorning LLP, and I practice exclusively in the area of family law. So that includes separation, divorce, spousal support, child support, custody access, division of property, a whole range of issues. And I have a particular expertise and background in domestic violence and domestic abuse because I was a Crown attorney for over 16 years and was the lead prosecutor in the Etobicoke Crown's office in that area.
Very
So
good.
tell us about yourself, Michael.
Myself. We don't have time for that. No. So I've been in real estate, as you know, for a very long time, and I work with everybody ranging from first-time buyers to seniors, empty nesters, baby boomers, people going into assisted living, uh, happy families with, children, pets, and the SUV and everything. But as you know, this is how our paths crossed. Is I'm Ontario's first divorce real estate specialist. So while it's not the only thing I do have specialized knowledge in selling the matrimonial home in a divorce scenario. And of course, that's how you and I met. So today I have the question that I think it's usually the first question. Whenever somebody calls me and says, I got your name from so-and-so, I have one question. Before we talk about selling the house, I have one question. I said, what is it? And they say, can I change the locks? He or she moved out. He or she had an affair. He or she, I'm sick of them. Can I change the locks if they've moved out? And I find it ironic because they always ask me first because locks are attached to the house. I'm the realtor, but it's a legal question. So I tell them what I've learned from you and from lawyers in the past, but I can't give legal advice. So today, for the privilege of everybody watching and listening, um, Leanne, can they change the locks?
The answer is generally no. And there's certain things that can happen in order for someone to be able to change the locks. But if those things have not happened, then you cannot. And it is a common question that I get as well. So both parties have a right to exclusive possession of a matrimonial home. And so that is why, generally speaking, you're not allowed to change the locks. And we can get into it, but there are certain situations where you are allowed to, but if you're not in one of those specific situations, the answer is a resounding no.
So our one of our recent interviews or discussions that we had, we talked about what is the matrimonial property. So just to sum it up, both spouses have equal right to any matrimonial property. You can't change the locks on anything that's deemed a matrimonial property. Is that accurate? Okay.
Whether
So
it's a
now
cottage
can
or a
you,
home, doesn't matter.
okay. Can you get into, so if somebody really wants to change the locks, what do they need to do via the law in order to do that the right way?
So in order to be able to change the locks, a party would have to get an order for exclusive possession of the matrimonial home. So that would involve going to court and you have to commence an application and then a motion, although the motion can be done urgently if there's domestic violence or something like that. And in order to convince a judge that you should get an order for exclusive possession, you really have to be in a situation where you have a significant safety concern. There is domestic violence in the home, usually meaning physical violence, although in some rare cases it could be emotional abuse and psychological abuse and that sort of thing. But the most cases really are dealing with physical violence. There's been physical abuse. Because a judge is very reluctant to, kick somebody out of their home, essentially. And unfortunately, in family law, there's often a lot of what we call he said, she said. So he says one thing, she says something else. A judge is in the middle of it all. We don't know who's telling the truth. And so it takes something, usually a little more than just saying something. There has to really be a strong case for that. And, if you can make that out in front of a judge, then you can get an order for exclusive possession. And in that situation, you can change the locks. The other scenario where you could change the locks, which is, much different, is if it's just on consent. So if one party, for whatever reasons, has actually moved out and they really don't care, and they're agreeable to you changing the locks, and they understand it's not, if they have equity in the home, or the home's the family property still needs to be divided, and they know that they're not forfeiting anything that way, but they're okay with the ex-spouse changing the locks, then that can be done by agreement. And I would suggest that it be done in writing and drafted properly by a lawyer.
And you said a judge is reluctant to throw somebody out on the street unless there's substantial evidence. Are they more willing to grant exclusive right of possession if the other spouse has already voluntarily moved out and has somewhere to live, or is that even relevant?
It might be a factor that's looked at, but it's really more, is there violence? So if you have a situation where, the best way to get your spouse out of the home, if there is violence, is to call the police and have them charged, because then they'll be on conditions on their bail that they're not allowed to have contact with you, and they're not allowed to attend at the matrimonial home. And then it would be very easy to go to a court and get an order for exclusive possession, but you almost don't need it really in that situation. So why pay the money to bring the motion, because your spouse is not allowed to go there anyway. But that's often the way that somebody ends up being out of the matrimonial home, is because they end up charged. But if you are applying for an order for exclusive possession, if the spouse has moved out, that's going to help your case, but it's really not. It's really more about, is there, safety issue? Is there violence in the home? Was there abuse? What are the reasons for why one party should get that order for exclusive possession?
Okay. And before we wrap this up, so something came up recently for me that is relevant to this topic, so I'm going to bring it up. Everything you've just talked about is rights to the matrimonial home. Let's talk common law for a minute, because that comes up more and more these days. Probably for you, definitely for me. So I have a client, left her, it's common law, left her partner for reasons I won't say. And I helped her find a new place to live, but the condo that she left is in her name. She owned it. It's common law. And for those who don't know, in general sense, I've heard you talk about this in other discussions we've had. In common law, the partner doesn't usually have a right to the other partner's assets unless there's an agreement. So in theory, the partner that's staying in the property doesn't want to leave, doesn't want to cooperate in the sale, and the person who's on title and paying all the bills has moved out. So she basically, she can't change the locks either, even though it's her asset and it's in her name and it's not a matrimonial property. She had a lawyer already when she came to me, and the lawyer said, I said, why can't we just throw him out? And even though it's not a matrimonial property, it's a principal residence. And like you said, you can't, if they've been together, this is also important, they've been together 20 years. So if that's where it's been on his driver's license, he's been getting his mail, and that's where he's lived for 20 years, even though there might not be a financial interest in the property, you can't just throw him out. So relevant to this topic, is it true that in that scenario, she also can't change the locks without a court order?
Yeah, that's correct. And it's funny, in that situation, even though they are in a common law relationship, it's almost like other areas of law than family law are coming into play. And, even though this person isn't like a tenant or something, you start getting into some of those areas of law, and whether someone can be, have a lock change, and what are the rights of somebody who owns the property to change the locks to somebody when it's their principal residence, and all of that. So there is, you quite correctly stated, Michael, like there are implications. You can't just go and change the locks, even in that situation. But it's actually not because of family law necessarily. It's because of other areas of law.
Right. Okay. So for anybody who wants to change the locks, there's the answer: is call the
Don't
lawyer.
do it.
Don't do it, or call the lawyer. Yeah.
Yeah.
Well, Leanne, always a pleasure, and hope everybody watching, listening, learned something if that's what they were wanting to know, or if they know somebody else that might be in a similar situation and they can help. So always great to chat. Look forward to our next one, and have a great day.
Thank you. You too. Always a
Okay.
pleasure, Michael.
Take care.
You too.